Thanks for coming along today. Nice hat, Richard. Lovely, yeah. Wouldn't have caught me wearing one of those. So, welcome. It's great to see you all. Hope you all enjoyed the lunch. And as the slide says, I'm Tim Corfield. I'm Managing Director of Griffin and King. I'm a Chartered Accountant, Insolvency Practitioner and Law Graduate. And after qualifying many years ago, I've spent about 20 years advising business owners about how to run profitable businesses. And in more recent years, I've specialised in rescue and recovery and debt advice. And Griffin and King are experts in all aspects of business rescue and recovery, including personal and corporate insolvency. We don't do anything else. We don't have an accounts department, we don't have an audit department, we don't have a tax department, and we certainly don't do loans. We get introduced to our clients at a most difficult stage of their lives, and our clients tell us we show empathy, compassion, consideration, and above all, professionalism to guide them through a very difficult period. But don't take my word for that. Have a look at our website and see for yourselves. And here's a couple of recent ones. Right, that's one from Peter that we had a couple of weeks or so ago, and Mike there, which was about a month ago. So, why are we here today? Most of you either advise business owners or individuals in one capacity or another, or you're in business yourselves. And this talk will give you a flavour of what we do and how we can help you to help your clients, like we do with Peter and Michael. And so that brings me to today's talk, where we'll be covering a change of direction. Did you hear that? Thank you, Charles. That was a golf ball. So, all duck. Right. This is a true story of a fairly complicated case that we've dealt with recently. It'll highlight how it's possible to take a loss-making business, trade the business through a liquidation and bring it out the other side operating under a radically different model, but most of all as a profitable business. And the specific areas we'll be looking at are what's a creditor's voluntary liquidation, that's a CVL to use a bit of technical jargon. How does a liquidator get appointed, particularly the technicalities at a creditors meeting, a brief look at the difference between an administration and a CVL, and what's a pre-pack liquidation, particularly the issues involved at the initial stages of the process, how the employees are treated and how the assets are sold. And what does a liquidator actually do? And you'll see our job is about dealing with practical issues to try and make sure the return to creditors is maximised as much as possible. And the whole talk will take around 25 minutes. So Airshot Limited. Duck everybody. Thank you, Janet. This is a story about a business that's been transformed from a loss-making business where sales and profits just didn't match up to costs to a profitable business matched to the current market. And the story starts when I got a call from one of the directors, Tiger, and he'd got our name from his accountant. And when we met the following day, Tiger and his co-director, Rory, explained that the financial problems of the company had built up over a period of time, over a few years. And here's a bit of background information. The company operated in the printing industry, and the main site was Coventry, which had been trading well for about 10 years. They employed around 60 people, so it wasn't a small business. They had around 45 in Coventry and 15 in Northampton, which was a much smaller operation. And around 12 months ago, they geared up with new equipment to maintain their sales. And the equipment was unfinanced and costing around £10,000 a month. Unfortunately, they lost their biggest customers shortly after investing in the additional capital equipment. and the market conditions were changing and putting pressures on margins. And they bought a separate printing business around 9 months ago, that's the separate location in Northampton, to replace the lost turnover. But this proved to have operational problems and only exacerbated the difficulties. And repayments were also to be made from cash flow, and that put more pressure on the cash flow. Now listen carefully to Tiger and Rory as they explain the difficulties of the company and how there was a profitable business buried there somewhere under all of the problems. And once they finished, I'll summarise to Tiger and Rory what they seemed to want from the process. And they wanted to make about half the staff redundant. They wanted to avoid any 2P liabilities. That's all of the potential liabilities arising from the transfer of the undertaking, protection of employment legislation. They didn't want there to be break in the service to the customers. They didn't necessarily want to carry on with the business that they bought in Northampton. They wanted to be able to renegotiate the capital debt and retain certain capital equipment. They realised there was no alternative but to write off quite a significant amount of unsecured debt through an insolvency process. And essentially they wanted to use an insolvency process to completely change the trading model of the business. So Tiger and Rory listened carefully, and once I'd finished they looked towards me and they both nodded, and I paused and said, "You'd better get ready for a few difficult weeks." And it seemed to me the most difficult part of the plan was to achieve a considerable downsize of the employee numbers and maintain the goodwill of the customers by not having a break in the trade. And I explained that using a CVL procedure, the liquidator would dismiss all of the staff who would be entitled to claim employee entitlements, that's holiday pay, notice, unpaid wages and redundancy. And a successor company that bought the assets off the liquidator, even soon after the appointment of the liquidator, would not acquire any 2P liabilities, even if it offered new contracts to previous employees of Airshot Limited. And that's why I call it a pre-pack liquidation. It's similar to a pre-pack administration, where a successor company is lined up as far as possible to acquire a business, except we're using a creditor's voluntary liquidation, that's a CVL procedure, rather than an administration. And that's where an administration or a pre-pack administration differs from a CVL. Under administration or a pre-pack administration, it'd be difficult to avoid 2P liability passing to the successor company, which may well frustrate any potential plan from the outset. But let me just stop the story and explain for a few minutes what's a CVL and how the CVL process works in the initial stages. So what's a CVL? Well, a liquidation really means just that. It isn't really a process that's usually used to sell a business. It's a process where a company ceases to trade, an insolvency practitioner is appointed who will sell all of the assets of the company, he'll liaise with creditors, he'll distribute any surplus funds to creditors and carry out an investigation into the conduct of the directors. The CVL is a director-led process, it's not a court procedure. And when the directors are satisfied that the company cannot continue to trade, they'd hold a board meeting and formally resolve that the company cannot continue by reason of its liabilities. And the business would usually cease to trade on the date of the directors' resolutions. And at the directors' board meeting, it would also be resolved to call a meeting of creditors and the date agreed, usually around 4 weeks after the directors' resolution in the board meeting. And at the meeting of creditors, a liquidator is appointed by the creditors by value of their debt, and the liquidation procedure commences from that date. And once a liquidator is appointed, he has the authority, amongst other things, to dispose of any assets of the company and dismiss the employees. So back to the story, and remember that Tiger and Rory wanted to carry on trade up to the date of the creditors' meeting to retain continuity and the goodwill with the customers. So how do they carry on trade in the company from the date of the directors' resolutions to the creditors' meeting date, which is around a 4-week period? And remember, this only works from a 2P perspective, because it's the liquidator that's dismissing the employees once he's been appointed at the creditors' meeting. So in this period of trade, Tiger and Rory need to watch out for the following. They can't take credit off suppliers. The directors need to demonstrate that the creditor position hasn't deteriorated. Any retention of title claims would need to be dealt with. Suppliers and creditors need to be spoken to. Staff need to be given immediate notice. The business needs to be financed during the period, but not using the assets of the company. And on that last point, how can the business be financed? And bearing in mind the bank account will be frozen and the directors shouldn't take credit off the suppliers. Well, that'll have to come inevitably from a connected party. And that'll either be the new venture that's already been set up, from an associated company controlled by the directors, or from the directors in their personal capacity. And if the directors haven't got access for funds to do this, it just won't work. So Tiger and Rory instructed a solicitor who would specifically act for them through this process. And the amount of finance that was needed during this 4-week period was around £25,000. And bear in mind that any appointed liquidator would still need to market the assets. So at no point could I guarantee we'd be able to sell the assets to Tiger and Rory. And another major issue was to talk to the major creditors and keep them on board. And in particular, there was the previous owner of the business in Northampton, and that's Bubba. This was the business they'd bought around 9 months ago, and Bubba was still owed around £150,000. And that deal was mostly in deferred consideration to be funded from future profits of Airshot Limited, which just simply wasn't going to happen now. And Tiger and Rory had explained that Bubba wasn't the easiest of blokes to deal with. So when Tiger and I met him at his house a few days later, I didn't know what to expect. He showed us into a small room where he sat himself in a nice easy chair, and Tiger and I were directed to 2 stools in front of him where we sat uncomfortably. And Bubba was around 50 years old and quite portly. His trousers and t-shirt had either shrunk since he'd bought them or he'd got bigger. And when he leaned back, well, I'll leave that to your imagination. There weren't any pleasantries like a cup of tea or introductions. Bubba went straight on the attack and proceeded to interrogate Tiger about the business. And I can appreciate Bubba wasn't pleased about the situation. But Tiger was only there really to try and reach an agreement about how Bubba could be rewarded through the new venture and mitigate Bubba's losses. But Bubba wasn't having any of it. He wanted 51% of the share capital of the new venture with a buyback clause for Tiger and Rory after 2 years. And that was the first time he'd really addressed me when he said, "You'll like this," just before he made the offer to Tiger. And I just sat there and I thought, Bubba, you've been watching too much Dragon's Den, mate. So before we left, Bubba told me he'd already got another insolvency practitioner, that's an IP, lined up for advice. And after making his offer to Tiger, Bubba had gone on to talk extensively about his business foresight. Perspicacity was the word he used several times. Now I'll admit, when I got back to the office, I had to look up what perspicacity actually meant. And what it means, if you don't know, is perceptiveness, clear-sightedness, cleverness, intelligence, foresight, that sort of stuff. Well, all I can say is that Bubba and his legal advisors must have been having a bad day at the office when they sold Bubba's business only a few months before. Most of the consideration was deferred and Bubba was simply an unsecured creditor. There were no personal guarantees from the directors. There was no debenture charge taken as security, which really could have been quite valuable as there was no existing debenture. There was a good debtor book, certainly enough to clear £150,000, and a debenture holder would have controlled any insolvency process. as far as I could see, there wasn't any due diligence that had been carried out. And I'd say, now I know what it means, there was absolutely no perspicacity whatsoever. So, back to Tiger and Rory, and the plan for them over the next few weeks looked like this. It was a directors' meeting. They signed the resolutions and set the dates for the creditors' meetings. They prepared a daily cash budget and they monitored it daily. They communicated with the major creditors. They secured the finance necessary as required by the cash flow. They gave notice to the employees and they engaged solicitors to act for the new venture and draft purchase agreements. And what were we doing at this time? So we were getting professional valuations of the equipment on the two sites. We were liaising with employees. We'd now received notice. We were liaising with creditors. We were getting information together for the statement of affairs that would be presented to the meeting of creditors, and we're monitoring trade and dealing with questions from Tiger and Rory. We're liaising with Tiger and Rory's solicitors regarding the proposed sale and purchase agreement about the assets. And so the plan was now well underway. But bear in mind what I said before, and at that point I couldn't guarantee a sale of the assets to Tiger and Rory or anyone else for that matter. If I wasn't appointed liquidator, it would be up to Tiger and Rory to negotiate with a completely different liquidator. And don't forget, Bubba had told me he was approaching another firm of IPs, and he was one of the biggest creditors. Oh, handsome chap. Oh, that's me. Sorry. So, how exactly does the liquidator get appointed by the creditors? Well, this is done by the creditors voting at the meeting of creditors on the value of their debt by a proxy form and a completed proof of debt. And if any creditor wanted to nominate a different IP to act as a liquidator, he'd do so on the proxy form. And proxies and proofs need to be lodged usually at the proposed IP's office by 12 noon on the previous day of the meeting. Otherwise, they don't count. And to have their vote registered, a creditor doesn't need to attend in person, providing the proof and the proxy have been completed properly. So back to the story, and things have become a lot clearer. The landlord of the main site were in fact the directors, that's Tiger and Rory. And they instructed an independent surveyor to assess the liability of the company as tenant, and with dilapidations it came out to over £200,000. And the employees of both sites seemed to support our nomination, and many voted in favour of our appointment. And we became aware that there was likely to be a separate offer for the Northampton site and assets, and the landlords of the Northampton site, who weren't connected to the directors, appeared to be supporting this plan. And bear in mind, any purchaser of the assets would need to get agreement with the landlord to occupy the premises. And Tiger and Rory had made an offer for all of the unencumbered assets and goodwill at the Coventry site, which was around £85,000, well above a break-up value. And solicitors were instructed to draft contracts in readiness of the appointment of the liquidator. But we still hadn't had any feedback from Bubba. So the creditors' meeting date eventually arrived, and we had many proxy forms in favour of our appointment, and we knew there was sufficient to actually confirm our appointment. And only 2 people actually attended the meeting. It was Prodrig, who was a representative of 2 of the major trade creditors, and he was from a nationwide firm of IPs, and his proxy form was for a joint appointment with his firm and Griffin and King. And then there was Bubba. I had a quick word with Prodrig before the meeting and appraised him of the voting position. So Prodrig withdrew his vote, his firm's proposal, once he was aware of the situation, and supported me as proposed liquidator. So then I had a confidential word also with Bubba. And so much for perspicacity. For all the bluster he'd shown, I was amazed to say I don't think he'd actually taken any advice. And he hadn't actually lodged a proxy as required by 12 noon the previous day, and not only had he missed any opportunity to nominate an IP of his choice, but he was also ineligible to vote and attend at the meeting. And I explained all of this but allowed him to remain and attend. And the meeting lasted about 20 minutes, and I'm pleased to say everybody supported my nomination, including Bubba. And so that was me appointed liquidator. So what happened after the meeting? And our two biggest concerns were to secure the two sites and then dismiss the employees. And I'd made arrangements for a senior member of my staff to be at Northampton following the meeting to speak to the employees and formally dismiss them. And I dealt with the ones at Coventry. And selling the assets became the next priority. And as I'd said, I'd had an offer from Tiger and Rory for all of the assets and goodwill at the Coventry site. And I was minded to accept that offer for the following reasons. The directors were in fact the landlords, and there'd be no issues of removal or rent payable, which there would be if I sold the assets to a third party. The offer made was considerably in excess of the breakup value. The offer included a valuation for goodwill, which no other interested party would have been prepared to pay for. And as the customers would continue to be dealt with by the new venture, this would have a very favourable effect on the realisation of the book debts, and this could be worth anything up to £100,000, I thought. And the offer was for all of the assets, so the costs of selling the assets piecemeal would have been considerably more. Time was, of course, of the essence, and Tiger and Rory wanted to get started with the new venture and continue to service the customers and retain their goodwill. And up to the date of the creditors' meeting, we'd received a number of inquiries for the assets at both sites. We'd provided details of the assets and said we'd be in touch following the meeting of creditors, assuming we were appointed. So once I had been appointed, we immediately contacted those interested parties asking, and we asked for any offers within 48 hours. And we only heard from one interested party as far as the assets at Coventry were concerned. That's from Henrik. And Henrik complained bitterly that I had not given him enough time to formulate an offer on certain assets that he was interested in. He threatened to complain to the highest authority in the land, whoever that may be, and clearly wasn't sympathetic with the imperfect world that I had to operate in to make a final decision. But I've no doubt that the sale and purchase agreement that we completed with Tiger and Rory over the next few days was the best available for creditors, and to have delayed on this process may well have resulted in this offer being withdrawn and a lesser sum being realised. And contrast that with the sale of the assets at Northampton, and there I had two potential purchasers, and immediately I was appointed I received an offer from Sergio of £15,000. And so I gave the other interested party, VJ, a deadline by close of play that day to finalise this offer. And before 5 o'clock, VJ offered £30,000, subject to landlord's consent, which we accepted. But VJ called me the next morning at 7 o'clock in the morning, before we'd finalised the contract, saying he's withdrawing his offer because he couldn't reach a satisfactory agreement with the landlord. So I had to go back to Sergio, who knew by that time he was the only interested party, and he immediately reduced his offer to £10,000, which I had no choice but to accept. It's very easy looking from the outside, like Henrik, to criticise the decision that an IP makes without having full knowledge of the facts. And so what happened to Tiger and Rory and the new venture? Well, so far so good. Most of the old customers have continued to trade with the new venture, and around 30 of the old employees have been offered new contracts. And what's the moral of the story for Tiger and Rory? Get the right advice and act upon it before it's too late. Tiger and Rory had probably traded on longer than they should have done, and they knew they needed to alter their direction and quickly. And once they'd taken advice, they listened to it and acted upon it, and because of that, they've still got a business and a living. And what would have happened if they hadn't carried on? What would have happened if they had carried on? Well, machinery would have been repossessed by the finance creditors, The unencumbered assets would have been levied upon by HMRC. There would have well been a winding up petition or writs and judgments, and the business was only really a couple of days away from the point where any sort of rescue plan just wouldn't have worked. And what are the warning signs that people who run companies and advisors to businesses should watch out for? Things like checks bouncing, things like operating at an overdraft limit or exceeding it, not paying suppliers on time, or arrears of pay, PAYE or VAT. And if any of these signs are present in a company, it could mean the company's insolvent, so watch out. And what about Bubba? Well, things could have been so different for him if only he'd taken advice or his advisors had shown a little bit more perspicacity. If only he'd taken a debenture charge, he'd have saved himself about £125,000. Wow. So what have we covered in today's talk? Well, we've looked at what's a creditor's voluntary liquidation. We've looked at how a liquidator gets appointed. That's through the creditors' meeting and the voting of the creditors. We've had a brief look at the difference between administration and a CVL. We've seen what's a pre-packed liquidation. We've seen that this commences with the directors' resolutions, how the employees would need to be dealt with, how trading is possible during this period, and how the creditors' meeting works and a liquidator is appointed. And what a liquidator actually does. And once appointed, the liquidator has the authority to dismiss staff and sell the assets. And we've looked at some practical issues that IPs have to deal with. And we've seen how Rory and Tiger have managed to reshape the model of their business from a company losing significant amounts of money to a profitable entity. And we've seen it's so important for directors to seek advice as soon as they see any financial warning signs. And insolvency is an area where most professionals don't deal with on a regular basis, and it's vital to know who you can contact to get some specialist advice at the right time and plan together. So, what do I want you to do? Have a think. Do you know a Tiger or a Rory out there or who are having financial difficulties with their company? Or what about a Bubba who's crying out for a bit of practical advice that could save them a lot of money? If you do, please speak to me or one of my colleagues. We're always pleased to have a chat or a meeting without charge to explore options, and I'm sure we can help. So don't hesitate, just give us a shout. What we're trying to do is avoid a formal insolvency situation. But the next best thing is a structured, planned insolvency process of which the director or the individual can retain a good element of control. Now at this point I'd usually ask my colleagues at Griffin and King to stand, but bearing in mind I'm being blinded by a light in front of me, I can't actually see where they are. So I think you've obviously met my colleagues at Griffin and King earlier, and obviously please feel free to talk to any of us. I think we've got the either the caps we're wearing or the Griffin and King ties, so I think you could probably spot most of us. But anyway, that brings us to the end of my talk, and I'd say thank you very much for listening. Thank you.